Why should almost everyone have a durable power of attorney? What happens to your financial accounts and retirement assets if you become incapacitated without one? Who should you choose as your agent? What specific powers should you grant them, especially around retirement planning? And how do you ensure that your durable power of attorney will be accepted by financial institutions? Well, here to talk with me about that is Harry Margolis. He's the author of Get Your Ducks in a Row. Harry, welcome.
Thank you, Bob. Those are great questions you're posing.
Well, we can answer some or all of them or others as well. So where to begin?
Well, why everybody should have a durable power of attorney. The reason is that if you become incapacitated, so you can't manage your financial affairs or you can't sign legal documents, no one else can do it for you unless you grant them the power to do that. And you do that through a durable power of attorney, which says that if I can't act for myself, this other person can act for me. And if you don't have that in place, then the only way your loved ones can help you out and take care of these things for you is they have to go to court. They have to get appointed your guardian or your conservator, different terms in different states. And that appointment takes time, it costs money, and it's administratively cumbersome. So once they're appointed, they have reporting requirements to the court, which provides some oversight, but also adds to the expense and the work for them. And while they're doing all this, no one can act for you. So it can take weeks or months, depending on what happens. And also, you don't choose that person. So sometimes there are fights among family members who's going to step in. But if you sign a durable power of attorney, which is a pretty simple document, you can choose who it is. They have the document. They can step in as needed.
So who should you choose as your agent, and what powers should you grant them regarding your financial accounts and your retirement accounts?
So you should choose somebody you trust, basically. I mean, most people often choose their spouses or a child if somebody's appropriate. So someone you trust who you think will step in and has the time and ability to take care of matters. Sometimes you don't have anybody in that role, and that can be problematic. So in those cases, perhaps an attorney will fill in. Some are willing to do this or not. Sometimes it means rather than having a durable power of attorney, you have a trust with a professional trustee. And it's another alternative, and there are pros and cons to both. But the power, if you can name someone under a power of attorney, it's a relatively simple document and easy to execute and to put into place.
And when you think about the powers that you're granting them, it would be typically what, to pay bills or pay your credit card bills or
Yeah,
take
I mean, well,
withdrawals from your retirement
yeah,
account.
I mean, the power of attorney can be pretty long with listing a lot of powers. In general, it has a plenary appointment, meaning you appoint someone to really do anything for you on financial and legal matters. And in theory, all you need is a one-paragraph power of attorney to do that. But it turns out that when you present it to a bank or the tax authorities or anybody, they want to see the exact power listed that they're trying to carry out. So the documents end up being pretty long. Some states have statutory forms, and those are good to use because the banks and other institutions are used to seeing them. So if they do have a statute, if your state has a statutory form, use that. And often the statutory form has check boxes for the different powers. So in most cases, you want to allow your attorney, in fact, to do everything. Where you may limit it, sometimes people don't want to give them the power to make gifts to themselves or to others, things like that. But in most cases, you want them to be able to do whatever's necessary. And if you're appointing someone you trust them to make the right decisions for you.
Right. And then people want to make sure that these durable powers of attorney are accepted by financial institutions. There are many, Fidelity, Merrill Lynch, others, where they have their own specific
Yeah,
durable powers of attorney that they want you to write or
yeah,
to sign.
right. So sometimes these institutions can be difficult. and not accepting powers of attorney when they should. One problem is they don't like older documents, which I call a staleness doctrine, which doesn't exist anywhere in the law. And in some ways is perverse, because if someone's incapacitated, why would you why would you be more likely to honor a document they signed a year ago when maybe they already started to lose capacity, rather than one they signed 10 years ago when no one questioned their capacity? But that's the way it is. But a lot of these institutions also have their own power of attorney forms, and they, for whatever reason, they're more comfortable with their own forms. So if you have investment accounts at a Fidelity or Schwab or any place like that, ask them if they have their own form, if they can provide it to you, so you can execute that as well as the general durable power of attorney.
Yeah. Harry, I'm thumbing through your book, and among the things that you mentioned here is how many agents to appoint.
Right.
My knee jerk would be one, but apparently there may be cases where you may want to appoint more than one.
Yeah, I think two is fine. And the advantage of two is you have backup. So one person is not available, the other person can serve. I'm uncomfortable with more than two because it just increases the possibility of miscommunication, and more communication it becomes necessary. So two is good. It's just two people have to keep in touch. But once you get three or more, you've got just I mean, it's there's just more links to so that everybody's on board and knows what's going on. When you do appoint two, appoint them jointly and severally, because you want them each to be able to act independently. If you don't put those magic words into the document, sometimes institutions will require them both to sign everything, which can get pretty cumbersome.
And what about alternates? You might have someone who is your agent, but you might want to name an alternate as well.
Yeah, definitely. I think it's good to name an alternate just in case the person you appoint is unavailable.
Right. And then also in your book, you talk about the notion of the difference between springing powers of attorney and current durable power of
Right.
attorney.
And this might not seem to make sense. So a springing power of attorney is one that only takes effect when you become incapacitated, which is kind of why you want to do it. You want somebody in place in that event. So why shouldn't they all be springing? The problem with springing powers of attorney is, how do you prove incapacity? So I appoint you, Bob, as my attorney in fact to start acting when I become incapacitated. And you go to the bank and the bank says, well, Bob, how do we know Harry's incapacitated? Then you got to go get a doctor's letter and prove it to them. So it's a lot easier if I trust you, I appoint you, and then when you need to, you can act and you don't have this extra barrier to stepping in.
Yeah. And what about how many copies of this do you need, and where do you store them, and with whom?
So probably make a couple originals. That's what we do. We usually keep one as attorneys. We keep one for our clients. But then the client can have one. They could have another original to give to the person they're appointing. So you can have multiple originals, which is different from a will, for instance. A will there's only one original will, but you can have multiple original powers of attorney. So I would say two or three makes sense.
Right. And the phrase, we call it a durable power of attorney, but you can change your mind, right? It's not necessarily like
Right,
it's
right,
set in stone.
right. So you can always revoke it. So you can just let the person you appointed, who we call the attorney in fact, you can tell the attorney in fact that you've revoked it and they can no longer act.
Yeah. Harry, we covered a lot of ground. Anything we missed, or is that a good sort of at a glance lesson
I
around?
think that covers it.
Great. All right, Harry, we are going to do a series of estate planning videos with you over the course of time. So this is the first in a many part series on everything you need to know about estate planning. So thank you.
Thank you, Bob.